Anyone who participates in IEP meetings knows that sometimes they can be really challenging. Everyone at the table wants to do what is right for the student, but oftentimes there are differences in opinion about how to achieve that goal. Given the diverse perspectives each team member brings to the table, conflict and disagreement is a natural part of the IEP process. There may be times when, despite our best efforts, families and educators disagree about what is best for a student with a disability. Informal discussions and meetings can resolve many of these disagreements. There are other times, though, when IEP teams cannot resolve their differences on their own. Ultimately, the school team has the obligation to offer every eligible student a free and appropriate public education. When parents and educators disagree, there are options that can help teams work through the conflict and find a resolution. The Individuals with Disabilities Education Act, or IDEA, includes 3 dispute resolution options: mediation, written state complaints, and due process complaints. In Colorado, parents and educators have an additional alternative dispute resolution option called IEP Facilitation. We're going to talk through each option and review basic requirements and procedures for each one. IEP Facilitation is an informal alternative dispute resolution option available to families and educators. In a facilitated IEP meeting, a neutral facilitator serves as a process guide for the IEP team members. This person does not make decisions at the IEP meeting. Their role is to support the IEP team in building an agreement throughout the IEP process. Facilitators use strategies and tools to make sure all IEP team members feel valued and heard, and that decisions are made by reaching consensus. IEP facilitation is voluntary, meaning both families and the educators must agree to participate. It's free for families and districts, and is a great option for teams who have a history of disagreement or conflict. The best part about IEP facilitation is that those who know the child best, the IEP team, retain all of the decision-making power. There is just the added support of a facilitator to help during moments of disagreement or confusion. Mediation is the most flexible and informal dispute resolution option included in the IDEA. In a mediation, the participants work together to resolve their disagreements with the support of a neutral third party, also known as a mediator. The mediator does not make decisions for the group. Their role is to support clear communication and help the group find agreement using problem-solving techniques. Let's discuss the benefits of mediation. Mediation is a voluntary process. Both the district and the family have to be willing to participate. Mediation is confidential. Nothing that is said in mediation can be used in a state complaint or due process hearing. Mediation is also provided at no cost to the district or the family. In other words, it's free. Mediation is flexible. There are no set timelines or specific requirements for holding the mediation. Oftentimes, mediations can be scheduled quickly. Finally, mediation works. Data reported by the National Center on Appropriate Dispute Resolution in Special Education consistently reports that mediation yields above a 60% average agreement rate. So what's the catch? There is none. Mediation is available to parents of students with disabilities and school districts. It's also been shown to positively impact the family-educator relationship. Written state complaints are another dispute resolution option included in the procedural safeguards. A written state complaint, or complaints for short, are a process where a third-party investigator from the State Department of Education reviews allegations of violations of federal and state special education requirements. Unlike mediation, this process has more specific requirements. A unique feature of complaints is that anyone can file a complaint request. This is the only dispute resolution option that someone other than a parent of a student with a disability can access. Even more unique, the complainant, or person filing the complaint, can file the complaint on behalf of a student or a group of students. This means that if someone had a reason to, they could file a complaint on behalf of an entire class, or school, or district. It is a powerful tool. Complaints can only look back 1 year, meaning the violation had to have happened within 1 year of the date the complaint is filed. The state education agency has 60 calendar days to complete the investigation and issue a final report. While the investigation is underway, the complainant and district have an opportunity to use mediation to resolve the issues. If they choose to participate in mediation, the 60 calendar day timeline is paused to allow time for an informal resolution if both parties agree to the extension of time. If the complaint is not otherwise resolved or withdrawn by the complainant, an investigator from the State Department of Education must conduct an investigation into the allegations. Investigators use a variety of strategies to gather information, including reviewing records, interviewing parents and school district staff, or site visits. If the investigation confirms a violation occurred, the report will clearly indicate the findings of noncompliance and the corrective action the district must take to correct the noncompliance. Remember, in written state complaints, the investigator makes the final decision, not the parent nor the district. There are many benefits to using a state complaint to resolve disputes. Unlike mediation or due process, the state complaint system does not require face-to-face interaction with school or district staff. Information is provided to the investigator by each party individually. Also, filing a request for a state complaint is as simple as completing a form and writing out the way in which the student or group of students' rights were violated. The Colorado Department of Education has a sample form available to use to file a complaint. Finally, if noncompliance is determined, the state is required to issue corrective action to correct past noncompliance, and they're also required to ensure the district maintains future compliance. This means this process can support schools in improving their policies and practices concerning students with disabilities. Like mediation, complaints are provided at no cost to families. The third IDEA required dispute resolution option available to families and educators is the due process complaint. Due process hearings are the most formal, legalistic, and contentious process available for resolving disputes. In a hearing, both the family and the school district can call witnesses to testify, submit evidence, and argue their case. An administrative law judge, or ALJ, makes the final decision after reviewing the facts and the evidence in the case. Parents do not need to have an attorney to participate in a due process hearing, but many families will hire an attorney to represent them because it is a legal proceeding and it is quite complex. Included in the due process complaint requirements is an opportunity for the parties to resolve their disagreement before going to a formal hearing. This is called the resolution session. In a resolution session, the parties meet together to try and resolve the case together. If unsuccessful, the hearing will go forward. Parties may also request mediation in place of a resolution session. Due process complaints can be filed by a parent of a student with a disability or by the district in certain scenarios. There is no fee to file a due process hearing request. Due process hearings will have costs associated with them for the district, and depending on the outcome, could also cost families. Attorney's fees, document preparation, expert witnesses, and other costs are some examples. Due process hearings are extremely contentious and typically have a negative impact on the relationship between families and educators involved. Despite the challenges, there are times when a due process complaint might be the right option to resolve the dispute. A common reason a family may choose due process is when a student's placement is the issue. A unique feature of the due process complaint is the stay put. Stay put refers to a student's placement during a due process complaint. If the child's IEP team recommends a change in placement, and the parent files a due process complaint because they disagree with the new placement, stay put means the child will not be placed in the new recommended setting until the hearing is done and a judge determines the proper placement, or the parties agree to a different placement. In other words, the student stays put in the previous placement. For more information about due process complaints and the rest of the dispute resolution options, visit the National Center for Appropriate Dispute Resolution in Special Education website. There, you'll find parent-friendly resources about each option to help you better understand each process.